Breaking news just seconds ago, a landslide vote in the House of Representatives on a bill that would try to force the release of DOJ documents related to Jeffrey Epstein, which started as a long shot bid months ago, now one step closer to becoming law. This was a nearly unanimous vote. The final vote, 427-1, just hours after some Epstein survivors gathered at the Capitol to rally support. So next step, the Senate, and then on to the White House for the president to sign this into law if it passes that chamber. The president now says he'll do that in a surprising political pivot after months of resistance to backing the bill. Joining us now is our chief Capitol Hill correspondent, Ryan Nobles. And Ryan, this vote just seconds ago now takes this one step closer to reality for the survivors and other advocates who have been fighting for it. The question had been just how many Republicans would get on board. The answer appears to be all but one.
That's right, Hallie. And as this resolution was officially gavelled and signed through the House of Representatives, there were cheers in the gallery just a few feet from where I'm standing, and we're told that there were survivors of the Epstein saga that were in the gallery.
All right, folks, welcome to Jack Mockler. Once again, the House voted 427-1 to pass the Epstein Files Transparency Act, a near-unanimous mandate forcing the release of millions of pages of government files. President Trump signed it into law, but his own name appears in those files, including documented jet trips and social contacts with Epstein and his convicted co-conspirator. This unprecedented bipartisan transparency push has created a crisis where the president who demanded the release is also its subject. Let's be completely precise about what the release has actually produced, because the precision matters enormously for evaluating both what has been disclosed and what the ongoing fight over what remains hidden is actually about.
Watching as this vote took place, and you're right, it was an overwhelming passage, 427 voting in the affirmative, only one nay, and that is Congressman Clay Higgins, who released a statement saying that he is what he described a principled no on this, saying that he has issues with the bill. And of course, Republicans in Congress, including the Speaker of the House, have said from the very beginning that they had issues with the way that this discharge petition, as it's called, came to be. The discharge petition is a maneuver that rank and file House members can use to bring a piece of legislation to the floor outside of House leadership. This was initially something that Republicans fought right up until the last minute. There was a group of breakaway Republicans that joined with Democrats to force this to the floor. But once it became a reality that this was something that House members were going to be forced to vote on, Republicans quickly came around and decided that it was responsible and smart for them to vote yes, including the Speaker himself. Today, though, he did hold a press conference and discuss his issues with the bill. He is concerned that it doesn't do enough to protect survivors, that it could put potential victims of child sex abuse at risk of their information.
The releases ordered by the transparency legislation have produced millions of pages of material, hundreds of thousands of documents, more than 3 million pages overall, according to official summaries and major news organizations. Those releases include FBI reports that had been previously withheld from public view, flight records documenting the movements of Epstein's private jet, emails between law enforcement officials and prosecutors discussing various aspects of the investigation, and interview summaries from witnesses who provided information about Epstein's criminal network. Some of those documents mention Trump's early complaints about Epstein, including an FBI report quoting the Palm Beach police chief saying that Trump contacted him and expressed gratitude that law enforcement was finally taking action against Epstein.
Being made public and that it could compromise future investigations. The supporter of this package say that they've written the bill in a way that would solve and deal with all these issues that the Speaker has. He's asking the Senate to change it, Hallie, and of course that is the next big question we have, is how the Senate will deal with this, and we could find that out here in the next hour or so when the Senate convenes.
Explain that, Ryan, because you now have the top Senate Democrat, Chuck Schumer, suggesting that he will try to bring this to the floor. He will try to take action, possibly in the next several hours here tonight. Of course, it would need Republican support. What are you hearing from that side of the Capitol?
Well, there's two ways that this could go once it reaches the Senate, Hallie. There's a very quick way, and then there's a much more lengthy and arduous process that this resolution could take. If they take the route that Speaker Johnson is suggesting, it could delay the passage and the release of these files indefinitely. So Speaker Johnson is asking for a long list of amendments to be added to this bill. That would require deliberations and negotiations among senators to craft the language that would make them feel more comfortable with voting yes. It would then have to come back here to the House for another vote.
The same document quotes Trump as calling Epstein's associate evil, suggesting a level of awareness about the criminal nature of Epstein's activities that has raised significant questions. Other documents detail the social and business contact between Trump and Epstein before their relationship apparently soured at some point. A newly released prosecutor email noted that Trump flew on Epstein's private jet 8 times during the 1990s, sometimes with Epstein's associate on board as well. These documented trips establish a level of social proximity that has become a central focus of political debate. But the most politically explosive dimension of the release story is not what was actually released. It is what was initially withheld from public view.
Before it made it to the president's desk. This doesn't seem to be something that most rank and file Republicans want to deal with right now because it keeps the story in the forefront. It's something that we'll continue to ask questions about. The other alternative they have is that they can do as Senate Minority Leader Chuck Schumer has suggested and just bring the bill to the floor this afternoon and vote on it, perhaps even by a vehicle called unanimous consent, where they just put it on the floor and say, is everybody okay with this? And if no one objects, the bill passes. That would prevent Republicans from having to deal with the continued questions about this, and it would also send the bill to President Trump's desk as soon as this evening. Now, we don't know which way the Senate Majority Leader John Thune wants to go as it relates to this package. He's deflected all questions about the Epstein saga from the very beginning, saying that this resolution was just a hypothetical issue because the Senate or the House had yet to pass it. It is no longer a hypothetical issue. It is something he's going to have to deal with. And Hallie, we've talked to many Republicans already on the Senate side who said that the bill should come to the floor and that they plan to vote yes. So much like how we saw it play out here in the House, if it makes it to the floor, it will absolutely get at least the 60 votes necessary. The question right now is in the hands of John Thune as to when the bill could make it to the floor and how quickly there'll be a vote.
Major news organizations reported that the Justice Department initially failed to include certain FBI interview files involving a woman who had accused Trump of sexual assault in the 1980s. These documents only surfaced after reporters discovered discrepancies in the database and lawmakers demanded answers from the department. The Justice Department subsequently released those files and characterized the allegations as false and sensational, and had been deemed not credible by investigators. The specific pattern of files mentioning accusations against the president being initially absent from the public database and only surfacing after press and congressional pressure is what has generated the accusations of a cover-up.
Ryan, I'm going to ask you to stand by for just a moment while we bring in our senior White House correspondent, Garrett Haake. And Garrett, we referenced the president's surprising reversal on this after months of resistance to backing the bill, saying this week that he would greenlight the GOP to back it, that he would, in fact, sign it into law. But there's another piece to this, too, right, which is some lawmakers suggesting that the president could avoid the Senate vote altogether. He could avoid having Congress manage this by simply directing the DOJ to release the files now himself. He was pressed about this today, right?
Yeah, that's right. And he really didn't answer. And this has been one of the interesting kind of riddles at the heart of this. I mean, this is a president who's never been shy about urging his attorney general or Department of Justice to take specific actions in a way previous presidents would not have. Here, there's a very clear action he could have taken if we take his words at face value, that he wants to see transparency here and wants to put this issue behind him, and could simply pick up the phone or use his social media platform to call for the complete release of the relevant files, a step he has chosen not to take. Yesterday, though, he did say in the Oval Office, when I asked him that he would sign this bill if it got to his desk, clearing up any confusion about whether he wants to see it simply pass the House and get.
This pattern has led to subpoenas of the Attorney General and created the political explosion that has dominated headlines. That specific pattern is real, documented, and genuinely consequential for how the Epstein files release is being evaluated by both sides of the political spectrum. The Justice Department's statement about the released documents added another layer of controversy to an already explosive situation. The department said that some of the documents contain untrue and sensationalist claims that were made against President Trump and were submitted to the FBI right before the previous election. But the department did not specify which documents it was referring to, creating confusion and speculation about exactly what allegations the statement was addressing. This raises profound questions about the role of the Justice Department in a situation like this. Why is the department preemptively denying allegations on behalf of a person who is not formally their client? Why comment on the truth or untruth of specific allegations without identifying which allegations, unless the department is really representing the president rather than the country? These are the questions that are fueling the political firestorm. At least one email referenced Donald Trump, sent from a federal prosecutor to unknown recipients. The email flagging flight records from the 1990s reflected that Donald Trump traveled on Jeffrey Epstein's private jet many more times than previously had been reported to the public. This revelation directly contradicted previous statements minimizing the nature and frequency of contact between the two men. The 427-to-1 House vote on the transparency legislation reveals the extraordinary bipartisan political consensus that formed around the demand for Epstein document disclosure. In a House that is deeply and bitterly divided on almost every major policy question, where party line votes are the norm and bipartisan supermajorities are extraordinary, this vote represents the most comprehensive available expression of bipartisan congressional consensus. The American people had a right to see the full documentary record of one of the most consequential criminal prosecutions in recent American legal history. The legislation requires the Attorney General to make Epstein-related government files publicly available in a searchable and downloadable format. The specific technological accessibility requirements reflect the congressional determination that the disclosure should be genuinely and practically available to the public rather than technically released in formats that prevent effective access. The president signing that legislation committed his own Justice Department, the institution headed by Pam Bondi, to producing those files with the accountability that the overwhelming mandate demanded. The political situation that creates is specific and significant. The president who signed the transparency legislation that committed his department to releasing the files is also the person whose name appears in some of those files in contexts that are politically sensitive, including the documented jet trips and the documented social contacts. That simultaneous position, having signed the law demanding transparency while being the subject of the files being disclosed under that law, is the specific political tension at the center of the Washington explosion. Then there is the missing and then released FBI interview dimension. The reporting on the initial absence and subsequent release of the FBI interview files involving accusations against Trump is the most politically consequential single event in the entire Epstein files release story. Reporters discovered discrepancies in the database. Specific files that should have been present under the disclosure requirements were not included in the initial production. Lawmakers demanded answers from the department. The department subsequently released the files and characterized the allegations as false and sensational and not credible. The department's characterization of the allegations as false and sensational may be accurate. The legal determination was that they were not credible. But the specific pattern of initially absent files that only surfaced after press and congressional discovery is the documented factual foundation for the cover-up accusations that have generated the subpoenas and the transparency fight. Let's now dive into the full substance of what the Epstein files release actually means, examining the specific documents that have been disclosed and what they establish about Trump's relationship with Epstein. The Palm Beach police chief account and what it reveals about what Trump knew and when is particularly significant. The political dynamics of a sitting president managing the release of files that include documents about his own relationship with a convicted sex trafficker have created a situation unlike anything we have seen before. The full picture of the Epstein file accountability story tells you about the intersection of judicial, congressional, and public accountability in one of the most consequential document release processes in recent American political history. There are several layers here, and each one matters for understanding the complete picture. Let's start with the specific documents that have been released and what they actually establish about the Trump-Epstein relationship. Careful examination of what the documents show versus what they do not show is essential for evaluating the competing political narratives that are being built around the release. The Palm Beach police chief account quoted in an FBI report describes Trump contacting the police chief around 2006 and expressing gratitude that law enforcement was finally doing something about Epstein. The same document quotes Trump as characterizing Epstein's associate as evil. Major publications have reported this as establishing what Trump knew and when, framing the police chief account as evidence of Trump's knowledge of Epstein's criminal conduct. The significance of the police chief account is specific and limited in ways that matter for accountability evaluation. It establishes that Trump was aware by approximately 2006 that Epstein was the subject of a law enforcement investigation and expressed relief that something was being done about him. It establishes that Trump characterized Epstein's associate as evil, suggesting awareness that she was not simply an innocent social contact. And it raises the question that has dominated coverage of this issue. If Trump was calling the police chief to express relief about the Epstein investigation in 2006, what did Trump know about Epstein's conduct, and when did he know it, given his documented years of social and business contact with Epstein before the investigation began? That is the accountability question the police chief account raises, and it is a significant and legitimate question that the released files provide partial but not complete answers to. Now let's talk about the documented jet trips and what the prosecutor email establishing that Trump flew on Epstein's jet 8 times in the 1990s, sometimes with Epstein's associate on board, actually establishes and what it does not establish about Trump's relationship with Epstein's criminal network. The jet trip documentation is significant for establishing the nature and the proximity of Trump's social relationship with Epstein during the 1990s, a period when Epstein's criminal conduct against his victims was ongoing. 8 trips on Epstein's private jet, sometimes with his associate, who was Epstein's primary recruiter of underage victims and who has since been convicted of sex trafficking. The trips establish a social proximity and a frequency of personal contact between Trump and Epstein that is relevant context for evaluating Trump's subsequent claims about the nature of their relationship. Trump has publicly claimed that he broke off contact with Epstein and that he was not a fan, framing the relationship as a distant and ultimately rejected social connection. The documented 8 jet trips in the 1990s provide specific evidentiary context against which that minimizing public framing can be evaluated. What the jet trips do not establish, and what requires clear precision in accountability journalism, is participation in or knowledge of Epstein's criminal conduct. Being on a private jet with someone is not evidence of participation in their crimes. The accountability question is what the trips establish about the nature and the depth of the social relationship, and whether that documented social relationship is consistent with Trump's subsequent minimizing public framing of it. The missing and then released FBI interview files, and what the specific pattern of initial absence, followed by court and congressional pressure disclosure, establishes about how the department managed the release, is perhaps the most politically significant element of the current situation. The transparency legislation requires the Attorney General to make Epstein-related government files publicly available. Reporters discovered that specific FBI interview files were absent from the initial production. Those files involved accusations against Trump. The department's initial production complied with the law in the sense of releasing millions of pages, but the specific absence of files mentioning accusations against the sitting president from the initial production is the documented fact that has generated the cover-up accusations. The department's subsequent release of those files, accompanied by a characterization that the allegations were false, sensational, and not credible, addressed the absence. But the timing, released only after reporters discovered the discrepancy and lawmakers demanded answers, is the specific factual foundation for the accusation that the initial omission was not inadvertent. Whether the initial omission was deliberate or inadvertent is a factual question that the congressional oversight process is now examining through the Attorney General subpoenas. The specific pattern of files mentioning accusations against the president, initially absent, discovered by press, subsequently released, is documented regardless of the ultimate answer to the intent question. Now let's talk about the Attorney General subpoenas and what they represent as a congressional accountability mechanism for the Epstein files release management. The congressional subpoena of the Attorney General over how the Epstein files were managed is itself one of the most significant accountability developments in the entire story. The Attorney General's management of the Epstein files, accountability, has been a subject of intense scrutiny. The subpoena of the Attorney General over the specific management of the release adds a new and more formal dimension to the congressional accountability pressure. Congressional subpoenas of a sitting Attorney General are themselves extraordinary. They represent a formal legislative demand for accountability from the head of the executive branch's primary law enforcement institution. The specific basis for the subpoena is the management of a congressionally mandated document release, including the initial absence of specific files mentioning accusations against the president. The Attorney General serves as the specific accountability question that makes the subpoena both legally appropriate and politically explosive. The overwhelming mandate for transparency is not compatible with a release management process that initially omits files mentioning accusations against the president who signed the legislation. The congressional subpoena is a formal institutional mechanism for examining whether the transparency mandate was followed fully or whether the release management prioritized the president's political interests over the congressional transparency mandate. The survivors and their lawyers have offered a perspective that is crucial to understanding the full picture. They say that both sides are using the Epstein case for politics instead of answers, that the focus on Trump's relationship with Epstein and the political warfare over the files is displacing the accountability for what Epstein did to his victims and for the failures of the legal system that allowed his conduct to continue for as long as it did. The Epstein files are not primarily a story about Donald Trump. They are primarily a story about a network of sexual abuse and sex trafficking involving dozens of powerful men, and the systematic failure of law enforcement, prosecutors, and the judicial system to hold that network accountable until far too late. The Trump-Epstein relationship is one thread of that story, a significant thread given Trump's current political position, but one thread among many that the files document. The survivor perspective that the political warfare over the Trump-related documents is displacing the accountability for what happened to real people who were real victims of Epstein's network is the most important context for evaluating the entire Epstein files release accountability story. The specific elements that have produced the documented explosion in Washington deserve precise enumeration. The overwhelming bipartisan vote for transparency, the millions of pages of released materials, the Palm Beach police chief account establishing Trump's knowledge of the investigation in 2006, the documented jet trips with Epstein's associate on board, the initial absence of FBI interview files mentioning accusations against Trump from the public database, the subsequent release following press and congressional discovery, the department's characterization of the withheld accusations, and the Attorney General's congressional subpoena represent the competing political narratives that are generating the ongoing political warfare. Each of these specific documented elements is part of the real and documented explosion that the headline is describing. Not a fictional dramatic moment in which the files are dramatically revealed in a single courtroom hearing, but a real and ongoing and genuinely consequential accountability process in which millions of pages of previously hidden government documents are forcing a reckoning with the documented relationship between the sitting president and one of the most notorious criminal figures in recent American legal history. Let's bring this all the way home because there are three things that matter most about the Epstein files release and what it means for the intersecting accountability stories it is generating. The first point is about what the overwhelming House vote on the transparency legislation represents as a bipartisan congressional accountability mandate, and why that mandate creates a specific and documented tension with the pattern of initial omission and subsequent pressure disclosure that has characterized the department's management of the release. That vote is the most unambiguous available expression of congressional determination that the public deserves full access to the Epstein files. The mandate it creates is not subject to executive branch discretion about which specific files to include or exclude based on their political sensitivity for the sitting president. The specific pattern of initial omission of files mentioning accusations against the president, followed by release only after press discovery and congressional pressure, is the documented factual foundation for the accountability question. The Attorney General's subpoena is examining whether the initial omission was deliberate or inadvertent. The pattern is documented, and the overwhelming mandate creates a specific accountability standard against which that pattern must be evaluated. The second point is about what the Palm Beach police chief account and the jet trip documentation together establish about the accountability question of what Trump knew about Epstein's conduct and when. The specific combination of these two documented facts creates the most significant accountability tension in the Trump-Epstein relationship story. The jet trips establish a documented social proximity to Epstein during the 1990s when Epstein's criminal conduct was ongoing. The police chief account establishes that Trump was aware by 2006 that Epstein was under law enforcement investigation and expressed relief that something was being done, raising the question of what specifically prompted that relief and what Trump knew that made the investigation feel like justice rather than a surprise. The combination of documented social proximity during the criminal period and documented awareness of the investigation when it came creates the specific accountability question that the Epstein files are documenting in ways that the minimizing public framing of the relationship as distant and ultimately rejected does not fully address. The third point is about what the survivor perspective that both sides are using the Epstein case for politics instead of answers means for how the accountability story of the Epstein files release should ultimately be evaluated. The most important accountability outcome of the Epstein files release is not the political damage or vindication it produces for Trump. It is the documentation of what happened to real people who were real victims of Epstein's network, and the accountability for the systemic failures that allowed that conduct to continue. The Trump-Epstein relationship thread of the accountability story is significant and legitimate, but it is one thread among many in a documentary release that ultimately should serve accountability of everyone who participated in or facilitated Epstein's criminal network. The survivor perspective that political warfare over the Trump-related documents is displacing that accountability is the most important evaluative frame for the entire Epstein files release. So where does all of this leave us right now? The transparency legislation passed overwhelmingly in the House and was signed into law. The department has released more than 3 million pages of material, including FBI reports, flight records, emails, and interview summaries. An FBI report quotes the Palm Beach police chief saying Trump contacted him expressing gratitude that law enforcement was finally taking action against Epstein and characterizing Epstein's associate as evil. A prosecutor emailed documents showing Trump flew on Epstein's jet 8 times in the 1990s, sometimes with Epstein's associate on board. Major news organizations reported that FBI interview files involving accusations against Trump were initially absent from the public database, discovered by reporters, and subsequently released after congressional pressure. The department characterized those allegations as false and sensational and not credible. The Attorney General's subpoena examines how the release was managed. Survivors and their lawyers say both sides are using the case for politics instead of answers. Washington has exploded over what the documents do and do not prove about a sitting president's relationship with a convicted sex trafficker. The accountability process, millions of pages, ongoing congressional oversight, and competing political narratives are genuinely and consequentially unfolding in ways that have produced and will continue to produce the specific and documented explosion that the headline is describing. The full documentary record of the Trump-Epstein relationship that has been disclosed in the released files establishes a specific timeline of their social and business contact, the specific circumstances of their documented break, and what the totality of the released documents reveals about the accountability questions that the police chief account and the jet trip documentation raise will continue to be examined by journalists, historians, and political observers. The intersection of presidential accountability, congressional oversight, and public transparency has created a moment of genuine significance that will reverberate through American politics for years to come. The overwhelming bipartisan vote for transparency represents a moment when both parties came together to demand accountability. The subsequent management of that transparency mandate by the executive branch has created a political firestorm that shows no signs of abating. The Attorney General's subpoena is a formal institutional mechanism for examining whether the mandate was followed fully or whether political considerations influenced the release process. The survivor perspective reminds us that behind the political warfare are real people who were victims of a terrible criminal network and whose suffering should not be forgotten in the political battles that have erupted around the documents. The millions of pages of documents released so far represent only the beginning of what will likely be a years-long process of disclosure and examination. As more documents come to light and more analysis is conducted, the full picture of what happened and who was involved will become clearer. But the political warfare that has already erupted around the release process demonstrates how difficult it is to separate accountability from politics when the documents involve powerful figures with significant political constituencies. The challenge for everyone following this story is to maintain focus on the underlying accountability questions while navigating the competing political narratives that have been built around the release. The Epstein Files release represents a moment of genuine accountability for the criminal network that Epstein built and the system that allowed him to operate for so long. It also represents a moment of political danger for a sitting president whose relationship with Epstein has been documented in ways that raise legitimate questions. The outcome of this accountability process will depend on whether the focus remains on the truth or becomes lost in political warfare. The survivors and their lawyers have offered the most important guidance for evaluating what matters. Both sides are using the case for politics instead of answers. The goal should be accountability, not political advantage. The truth should be the priority, not scoring points. Whether that guidance is followed will determine whether the Epstein Files release ultimately serves justice or becomes just another chapter in America's ongoing political warfare. The coming weeks and months will bring more revelations and more analysis as the documents are examined by journalists, legal experts, and historians. The Attorney General subpoena process will continue to unfold. The political debate will continue to rage, and the survivors will continue to watch as their trauma is used for political purposes by both sides. The most important accountability outcome will be whether the release ultimately helps survivors get the justice they deserve and whether it prevents similar failures in the future. Everything else is secondary. The truth is what matters. The truth is what the documents reveal. And the truth is what will ultimately determine whether this release represents accountability or just another chapter in America's political dysfunction.